which is our LawTechLab that we've launched at UCT. And so we're helping from the LawTechLab with the organizing of this as well. And the LawTechLab, it's a new thing that we've just started at UCT, where we're going to be doing a lot of teaching of law and technology, and we're going to be doing practical hands-on work with students, and we're going to be doing research into topics that happen at the intersection of law, technology, innovation, and access to justice. We're going to be doing things like holding startup competitions and a lot more events like this as well. And we're also going to be having, we're going to be doing a blog series very soon, where we're going to be getting input from the industry on a lot of topics related to law and technology. If you'd like to have a look at that, it's lawtechlab.africa is the website. And if you're interested at all in any of those things, please drop us a message. So that's my side. That's where I'm coming from. I'm going to introduce Alison soon, but I think I first want to just introduce Rebecca as well. Rebecca is a Scrum Master at the moment at Law for All, and she is one of the main organizers at LegalHackers. And maybe she can tell you a little bit more about LegalHackers and what it is, especially for those who are joining us for the first time. Rebecca, are you with us?
Sorry, I couldn't disable the mute. Am I able to, I can't actually put my video on either. So if someone can just allow me to do the video, that would be wonderful. Otherwise, you can just hear my voice, everyone. That's also okay. I do need permission to just, there I am. So awkwardly, I have my other background on. We are running the Agile conference today and tomorrow. That is SAGSA. So this is not the right committee background, but there we go. Yes, I am a Scrum Master and an Agile coach at Law for All, and I also introduce new ways of working into law firms. But that's enough about me. I'm going to introduce LegalHackers. So I'm going to give you the mouthful, bearing in mind that LegalHackers is actually an international organization with different chapters all around the world. We started one chapter here in Cape Town last year called the Cape Town Chapter. And we're hoping that maybe a Johannesburg chapter also wants to be opened up. But basically, LegalHackers is a global movement of lawyers, policymakers, designers, technologists. What is that word? Technologists, but I'm going to use it anyway. Academics who want to explore and develop creative solutions to some of the most pressing issues at the intersection of law and technology. So this happens through local meetups, hackathons, where you put developers and lawyers into the same room, workshops. LegalHackers really spot issues and opportunities where technology can improve and inform the practice of law, and where legal practice and policy can adapt to rapidly changing technology. So that's a mouthful. But basically, we are pretty new here and learning as we go. Some of our previous events have been how 3D printing can shape social causes, privacy and data protection, agile and law. Last month, we had our first in-person event actually at Law for All offices, and we did a lean coffee. So nice to actually see people in person again. But this way we get to have more people, and I'm so excited to see the great turnout today. So anyway, how do you want to get involved? You can get involved in many ways. You can attend our meetups. I will share our actual meetup page on Meetup. But we also realize that not everyone uses Meetup. So maybe I'm also going to start a LinkedIn page to better advertise our events. We're always looking for sponsors, potential speaker ideas, and even committee members. So if you want to get involved in any way, please feel free to send me a message. Okay, that's all from me. I'm really, really looking forward to tonight. And thank you, Alison, for joining us today. Over to you, Neil.
Awesome. Thank you so much, Rebecca. Alison, I'll briefly introduce you. So Alison has got two capacities that I think give her a very unique and valuable viewpoint on POPIA, which we're excited to have her share with us this evening. So she has recently been appointed to South Africa's information regulator, which is the one capacity. And then the other capacity is that Alison also played a very big role in the drafting of POPIA, where she was a part of the South African Law Reform Commission, specifically the project on privacy and Data Protection, which was the commission that led to the POPI bill. Alison is also a renowned human rights lawyer. She's a colleague of mine at the Democratic Governance and Rights Unit at the University of Cape Town, where she's done some amazing work with the judiciary and the judicial appointment process and accountability of the judiciary. So I won't go into much more detail than that. So thank you very much for joining us, Alison. We really appreciate it. And we look forward to hearing what you want to say. Maybe just the last thing I'll mention, it is in the spirit of Legal Hackers that we would have engagement. So if you would like to take questions at any point, you're welcome to. Otherwise, we can do questions at the end. But even if not, if people just want to share their opinions or ideas in the comment section, please feel free to do that as well. More than happy to hear from the audience. Thanks, Alison. Over to you.
Lord. I know we've got a short time to go until POPI kicks in. So if there are a lot of questions, I may not be able to answer all of them, or I may just not be able to answer them because I don't know the answer. But in which case we can always try and answer those questions offline. What I wanted to do tonight, and you can tell me at the end if you think it's useful, is really to explain where data protection comes from, and particularly in South Africa. I think there's a lot of, certainly it seems to me, a lot of anxiety about POPI. I have been told a great deal about people selling POPI compliance packages, people going around saying, you know, it's a 10 million rand fine, oh my God, you have to do this, that, and the other thing. And you know, one of the key things that I would say is that I'm always interested in people telling me what POPI compliance looks like, because we haven't actually done it yet. So we don't actually know what it looks like. It's like a court sitting down with a piece of legislation and starting to develop a jurisprudence. That is where we are. So you know, when people are telling you this or that is definitely the interpretation of POPI, you know, I would say just settle down. We've got a way to go. But just to begin with the question of sort of how we got here, the intention, in fact, was that POPI would form part of a package of laws which were originally called the Open Democracy Bill. The Open Democracy Bill had 4 parts to it. One was access to information, which became PIA. There was a second part which dealt with whistleblowing, which became the Protected Disclosures Act. There was a third part dealing with open government, which disappeared and has never been seen again, and warrants a bit of thinking about. And then thirdly, the issue was data protection. And that was the sort of package of legislation that was then presented by cabinet, signed off by cabinet, and everybody started looking at it. There was a deadline for passing the section on access to information back in 2000, and the idea at that point was that we had to carve out the section dealing with access to information and get that through Parliament first, and then everything else would follow. So that was really when discussion started about that particular piece of that omnibus law. So it started looking at access to information, and then looked subsequently at whistleblowing in the Protected Disclosures Act. The issue around data protection was not one that was familiar to people in South Africa. We had people certainly from different places. Interestingly, the French Data Protection Agency, the CNIL, came out to South Africa and were trying to talk to people about privacy. And it really, you know, it really just wasn't an issue that was top of mind for people. We were really concerned about transparency, making sure that the history of a secretive necessarily so. ANC meeting up with a secretive government structure in South Africa would just yield a whole lot of secrecy. And I think that was, you know, one of the primary issues we were concerned about. And privacy just wasn't that big a thing, certainly from our point of view. There were enough people, fortunately, who were concerned about it that the Justice Committee decided to report, in its report, to talk about personal information. And the report pointed out that the prior legislation did deal with private information, and it did deal with correcting private information, but it didn't deal with other aspects of the right to privacy, and particularly, you know, the whole concept of data protection, gathering, use, disposal. None of those issues were dealt with. So what they did is to request the Minister for Justice to introduce privacy and data protection legislation in Parliament after thorough research of the matter as soon as reasonably possible. So that was in 2000. The Minister then referred the issue to the Law Reform Commission, and a project committee was instituted, and I was on that project committee, which began work in 2002. It's important to note, and for reasons I'll explain later, that the sort of project leader of the committee was somebody called Johan Neethling, who's written extensively about privacy law in South Africa. And he had a number of strong views which made their way into the legislation. So what the Law Reform Commission was tasked with is looking at the right to privacy broadly, but more specifically, data protection. And the idea was to provide legal protection for people where personal information was being processed by somebody else. And, you know, that was considered broadly collecting, storing, using, and communicating the information. The idea was that the processing of personal information is actually a threat to your personality right. And I mean, this is a German concept, and it's not actually used in South African law, but it's useful just to explain what it is that we're talking about. Your personality, not you, but your personality in the sense of your cyber personality, is something that you have a right to. You don't own your own data, your own personal information in the way that you own a cup or a mug or an annoying dog. You own, you have a right to your personality, and that's very much, it's basically a German concept. But the idea is that people who are compiling and distributing personal information create a threat to people's privacy and to their right to personality, and that the acquisition and disclosure of false or misleading information can lead to an infringement of your identity. The whole question of the right to privacy itself, obviously in the Universal Declaration of Human Rights, in South Africa's common law, Section 14 of the Constitution, the actual right to informational privacy is only recognized in one case, but it has been recognized in South African law. So in the drafting of the legislation, you have to find a balance between competing interests. So you're looking at an open and accountable society on one hand, so transparency, very concerned about that, and the right to be left alone. That's one of the classic formulations of the right to privacy. In doing many of the things that you do in terms of the Constitution, you know, you have a trade, you have an occupation, you buy and sell things. In relation to all of those, you need personal information. You can only really fulfill your functions properly if you have access to sufficient personal information. So the idea was that this had to be dealt with all in a piece of legislation. There was a lot of awareness that there were changes afoot, and that the surveillance potential of powerful computer systems promoted demands for specific rules governing the collection and handling of personal information. The question there is no longer whether you can get the information, but rather whether it should be gotten and where it is obtained, how it should be used. If you can protect information on which decisions are made about individuals, you can also protect fairness, integrity, and effectiveness of decision-making processes. The committee basically had to choose between, I'd say, two main models, and the one was the approach in the EU, and those instruments, the Council of Europe's 1981 Convention for the Protection of Individuals with regard to the automatic processing of personal data, and the 1981 OECD guidelines governing privacy and transborder data flows, they had a profound effect on the enactment of laws around the world. And the OECD guidelines introduced the 8 principles of data processing. We had to look at those, but we also looked at the Data Protection Directive from the European Union in 1995. And what we did was look at that as setting a baseline common level of privacy that reinforced existing privacy rules, but established new rights. And that was, I think, something that we were particularly interested in. It does only provide a basic framework. You know, in all jurisdictions, you would have to develop legislation. The idea, I think, was that we would take these conventions and directives as the framework, and that is the one sort of framework that exists, and now we would talk about it as the GDPR. So the legislation that's now applicable in the European Union. We did have other options though, and one of them was obviously to look at the more American model. We decided that that was probably not appropriate given the connections and the similarity between the understanding of the right to privacy for us and the right to privacy in Europe. So I think that was quite persuasive. And we also had the, I forget when the Schrems decision came down, but I think we were also quite persuaded by the, you know, the ruling in the European Court of Human Rights that the American system doesn't provide sufficient safeguards. We needed, in the view of Professor Neertling, to deal with the privacy of public bodies as well as private individuals. And I think companies, and I think that's one of the things that's been, you know, people have sort of raised their eyebrows about, because normally you only deal with the privacy of real people. However, we do in POPI look at and recognize the privacy rights of companies. And that has caused some confusion and difficulty. The intention was really only to look at it in the most skeletal and basic sense, that there might be situations where companies would have privacy rights, and in those circumstances, but only when, you know, the circumstances allowed, there would be privacy rights that we identified. One of the things that we did want to do, though, is not have a very long piece of legislation. And I mean, for those of you who feel that this legislation is pretty long, I mean, I would have to agree with you. But the idea is that it wouldn't drill down and deal with specific sectors. So that was then the proposal, that there would be different sectors, and that those sectors could then have codes of conduct, and that the regulator or the governing body, that there would be a governing body, and the governing body would then be in a position to sort of to recognize that there are different processes and different information in different sectors, and that you could have a code of conduct which would then deal with that. There wouldn't be sectoral laws. So unlike the Americans, we wouldn't have legislation dealing with particular sectors. And so that's the road that we didn't take. We obviously didn't go the route of complete self-regulation. We felt that had not really worked in any of the jurisdictions that we looked at. There was some question at the time as to whether legislation was actually the right thing to do at all in protecting information in this area, and that in fact technology is going to provide the protections that you need. So you should really focus on technical standards and not on legal principles. But we did not agree with that. We said that you needed to set out the principles in the legislation, allow sectors to create the codes of conduct, and then as the technology developed, and I think that's one thing we were keenly aware of, is that technology would develop at a pace that would easily outstrip any legislative process, and anything that we put in the legislation about, using tech to secure privacy was just not going to stay current. So hence the sort of reliance on legislation rather than tech. There has been very little by way of implementation or learning about implementation in South Africa. As you know, this legislation is only going to kick in about a month, and at that point, I think things will get really interesting. The questions that the regulator is getting at the moment are some of them quite straightforward, and some of them really, really complex. And I think those are the ones that at the moment we're having to say, look, we really can't, we can't give, as the regulator, we can answer some questions, but we can't give people the answers to what are effectively requests for legal opinions on issues that are particularly complicated. So as the regulator, what we're trying to do at the moment is put out as much information as we can, as consistently as we can, about what is going on. We've set up some social media platforms, which I think started operating in January, and we're trying to use those to share information. There's also the website, which has many of the forms on it. But I think if you come back to the sort of first principles, and that's really what we did in the Law Reform Commission, is to look at, how does misusing personal information impact on your personality right, your cyber world personality. There are rights that you have in relation to that avatar, for want of a better word, needs to have information that's correct. You have the right to correct that information if it's wrong. Particularly personal information should not be disclosed. Your avatar has the right to wear clothes. there is no right to take parts of that and sell that on to some third party. It's not a thing to be bought and sold. So I think that's some of the basic principles that we engaged with. But of course, how they've translated into the legislation itself is another question, and we're learning. I think every day as new questions come in, we're looking at, what you thought you were saying, and then what the legislation, the words on the page, which sometimes read differently to the way you intended them to. So I think, Neil, if I can perhaps stop there and say that I'd be very happy to take some questions.
Okay, fantastic. Thank you, Alison. I must say I've heard you speak on this topic more than once now, and every time I learn many new things. So thank you.
Are we losing Neil?
I think we may have lost him.
He's back.
Are you sure?
While I wait for Neil, maybe I'll just pop. Oh, Neil, you back?
There he is.
Did I disappear?
Yep.
Yes, and you froze.
Oh, sorry. Oh dear. Sorry about that. Okay, well, I was just inviting questions, but go for it, Rebecca.
No worries. I just jumped the gun. I just want to double check. Can all the attendees, how would you like them to ask questions? Can they post it in the chat? And are they able to turn their videos on?
I think that's a technical question, Neil.
Yeah, that's a technical question for you, not for Alison.
Yes. Okay. I think both of those are fine. So if you would like to post questions in the chat, then I will read them. Otherwise, if you would like to just put your camera on, put your voice on, and speak directly, I think that's fine as well. I'm not sure I'll be able to see if people put their hands up, but if you get the mic, go for it. Okay, it would be great to get the links to all the social media posts. Is there somewhere that they would be able to find that, Alison?
It's a good question. I guess on the information regulators website. Just 1 minute. Sorry, I have no idea what's going on with the dog. Yeah, that's. And I'm sorry, I can't tell you off the top of my head what the Twitter account is, which is. I promise I will learn it so they can just rattle it off in future.
Oh, someone else has found it for you. So you have been saved.
Regulator essay.
Oh yeah, someone's posted it there. Sarah.
Oh, look at that. Fantastic. Yeah, we're trying to.
Okay.
No, good.
So I think Neil's reception.
Okay, we have. My reception does seem to be a bit buggy. Sorry about that. We've got some questions in the Q&A section. So from Kim Lisa, we've got so often I hear that operators selling their software solutions as POPI compliant. Is it true or false that a software solution can be POPI compliant, or is that a misleading statement according to the law?
Yeah, I mean, I would question whether software can be POPI compliant. I think the question is how you use the software. I mean, it strikes me as would be odd if software is able, I mean, the act is long, there are many nuances. It would really surprise me if a piece of software was able to just take whatever data was thrown at it and then make it POPI compliant. I mean, that would be a remarkable piece of software, which I personally really like to see. I mean, that would be AI of note. What I think people are doing is that they are selling solutions, and people are really anxious about compliance, and they really are concerned that they're not going to comply, and they are paying money for training courses and for, people to come in and organize their information for them. And I think that's fine. It's a free market, but that doesn't sound very kosher to me.
Can I maybe
Also
make
sounds a bit odd.
yeah, a comment
as
on
a
that,
software
Alison?
developer.
What we're doing in our software development team at Law for All, we're trying to just identify, number one, what is actually considered personal information and where do we keep the personal information. So it's been quite a manual process, because a lot of the protections is we do have all this personal information, but we have no idea where we're storing it. And it's like making sure that we have identified what it is. And they're confusing. We have a whole list of things where we're not even sure if it qualifies as personal information. And then ultimately, if we are asked, we can at least say, this is exactly where we keep our personal information. So maybe that would align to it being POPI compliant, is more just an awareness of what we have and where we hold it.
I think one of the things that people are going to have to answer, and it's a tricky one for people who have existing databases, is where did your information come from? Because you didn't have an audit trail, I assume. You didn't think at the time when that information was gathered, or whoever gathered the information may well not have been, not be the person who currently holds the information. Where did that information come from and why? And that's actually a really central question in POPI. Why are you gathering this information at all? Like, for what purpose? If you can't answer the question as to why that information is gathered and for what purpose, you're already in somewhat murky waters. The fact that now you have the information and you're going to organize it in such ways that you know that this is personal information and that isn't personal information is great. I mean, that's obviously a good thing, because you're not going to want to further process personal information that you've gathered. But you have to start somewhere. You have to jump in somewhere. You can't say, well, we're going to wait until everybody's had a chance to rejig their databases so that they know where all that personal information comes from, because it's kind of never going to happen. So it's something that we're just going to have to jump in, and people will have to have the best explanations that they can in terms of where the information has come from and why they have it. So I think that's key. I see Caroline has said that she says she thinks technologies can assist with facets of compliance, and I think that's probably the most that you can say. I think there's software that can help you and there's software that doesn't help you. But to say that software is POPI compliant is, if it is, that would be great, because then we can resign and go home and we can do something more interesting with our lives and worry about personal data. If the machines can do it, that's great. Just some other questions in the chat. Is there a time frame for compliance? Yes, there is. You have to get yourself sorted by 1 July. And anybody who says that's too short a time frame has not been paying attention, because we have had 4.5 years of preparation for this. So, like, just, if you're going to complain about timeframes, that complaints department is closed. We're now really looking on how to roll this thing out. A question in the chat: is there an established plan on how to monitor compliance? That's a very interesting question. Monitoring compliance is something that regulators find difficult to do proactively. There are some things that we can do. So there's some things like codes of conduct. We can say whether a code of conduct is good or not. But what tends to happen, and I think you guys will know this, is that it really, the rubber hits the road when there's a big data breach. And then everybody's like, oh, it's very bad. How did that happen? And then, you know, try and work backwards to see what the problem was. The problem with data breaches is that in many cases they involve cybercrime. And you have to remember that the regulator is not there to deal with cybercrime. We do not have that mandate. Nobody has that mandate right now. I mean, to the extent that anybody does, I guess it's the police. So if there's a cyber crime, that is then dealt with in terms of the cyber crime legislation. The regulator's involvement is where there's a data breach involving personal information, where personal information was processed in a way that is contrary to the requirements of POPIA. So it's something that I think people have to remember, because certainly the regulator is not going to be in a position to deal with cyber crime. And I think that a lot of what the regulator will do is exactly what a court does. I mean, courts don't monitor the enforcement of laws. Courts deal with people bringing them a problem where a law has been broken. So I think that's really going to more be the regulator's role. It's not, you know, a kind of big brother, you know, walking around requiring people to, you know, show their POPIA compliance badge. It's just, that's, you know, that's not really how the thing was designed. But if people have issues, the idea is to then come and, you know, talk to the regulator. And yeah, I think that's, I don't know if there are other questions that you guys.
We've got some questions here, Alison, in the Q&A panel. I think there's one here I'd like to ask you about. It's about the draft national cloud and data policy, which was announced on the 1st of April. That might be your answer.
Yeah, I think that kind of is my sort of. That's really all I have to say.
Okay. Well, the question is, will you be part of the stakeholder consultation process?
Yes, we will.
Or will the regulator be?
Yeah, we are.
Okay.
And yeah, you know, obviously there are a number of really serious problems with that policy, which is draft. So I would hope we can get a lot of that sorted out before it goes to the next phase, next stage.
Awesome. Okay, I think there's another question in the chat from Costa.
Yeah. Parental consent. Well, I think the question of children is an interesting one, and there was quite a lot of debate in the Law Reform Commission when we try to figure out what to do with children. And one of the key questions was, when can children participate in platforms where those platforms require that their personal data be processed? And at that point, there were sort of two possible benchmarks. The one was 13 in relation to, that was I think a Facebook rule, which had to be 13 or older. I can't remember what we as the Law Reform Commission said, but certainly by the time it got to the Justice Committee, the parliamentarians were very concerned about that and thought that 13 was far too young, and they've put 18 in, and I think that's going to cause problems. So, because obviously people under 18, children, are using apps that use personal data all the time. And I don't think that that's going to be something that we can deal with in terms of prior authorization. So yeah, that's, I think, one of those things that we're going to have to just work out as we go in practice, because the other problem is, of course, platforms have different ages themselves, which they build in. So to what extent parental consent could be a factor? I think the question of children's personal information is going to be a really vexed one.
Do you mind, Neil, if I ask a question quickly? I'm being selfish.
It, yeah.
Kind of follows on yours, Alison. So the title was also POPI Progress and Problems, and you've mentioned a few. I've just heard you subtly mention maybe the fact that we have that POPI does cover companies that may bring some problems and children, but what, in your personal opinion, is going to be the biggest problem with POPI after July?
Well, I think there's nothing that gives me sleepless nights, but that's more because I sleep well than because of the size of the problem. I think there are a couple of things that immediately concern me, and one of them you may be aware of is that the portal for registration of information officers was intended to go live on 1 May. And for those of you who've gone to the website to try to do that, you will see that there is a notice which says something along the lines of, please be patient, we'll get back to you. So that registration portal isn't operational right now, and it needs to be. So I think that's one thing that's very, very much on my mind right now. The capacity of the regulator to deal with codes of conduct, I think, is also, there's not enough staff in place. The regulator is still hiring the people that it needs to have to run the operation. So it's a bit like building a plane while flying. It's a little nerve-wracking. So I think I certainly have concerns about bringing enough people in quickly enough, and then being able to do the job quickly enough. I think one of the concerns I have, and it's ironically it's not a POPI concern at all, it's the fact that people are only really thinking about the regulator's jurisdiction in terms of POPI, and nobody appears to care about my pet piece of legislation, which is the Promotion of Access to Information Act. It's kind of startling to me that there's literally going to be a regulator in place that has order powers in terms of the release of information, which would include data sets, and nobody appears to care, which is sort of, guys, there's this whole other law, and we're going to be able to do stuff about it, and you really should think about it and read it and talk about it, because it's not just a question of having a regulator that shuts down access to personal data and makes it harder to process that personal data. It's supposed to open the door to really new levels of transparency. I mean, that's what POPI itself is also really intended to do, is bring transparency to these issues. How did you get my name? How do you have my phone number? What are you doing with it? I mean, a lot of that, it's a very basic transparency question. It may be something that is dealt with in zeros and ones, but if you ask the question in a human way, you just need to understand it as people saying, but I want to know what you're doing with my stuff. It's not a hard, it's not as technical an issue as I think it seems. And especially if you pair that with access to information at local government level, national government, private bodies can be subject to access to information requests. So I think, You know, I think that's one of the things that kind of worries me, is that nobody appears to know that, or at least if they do, they're not telling me. So I worry about that.
Maybe something to expand there, Alison. I'm glad you bring that up, because I've tried a few times recently to find out where companies have got my cell phone number with much difficulty. There's a question in the Q&A as well about the regulator's role when there's violations of the acts. Perhaps you could just give a little bit of an overview of what are the noteworthy powers of the regulator with relation both to POPIA and to POPIA.
You mean aside from the 10 million rand fine?
Yep.
That's the biggie. That's the one that people are worried about.
Yeah.
The regulator has a wide range of powers in relation to mediation, and it's one of the things that's really built. We really tried to bake it in, that the idea is not that you come to the regulator who whips out a very large stick and starts beating somebody over the head with it. The idea is that you actually have some kind of dispute. You know, I want people to do this and they're not doing it, or they're not telling me that. And the regulator is then a place where you can fix that by getting people to talk to each other. So that may be a lunatically optimistic approach. But in many cases, particularly, I think in relation to government, a lot of government workers, civil servants, bureaucrats are, the safest thing a bureaucrat can do is to do nothing. The safest decision is to not make a decision. And in the sort of environment that I think a lot of our public servants are in, where, you know, there's a lot of conflict, there's a lot of disagreement about what government should and shouldn't be doing. And a lot of the time, those public servants kind of need a cover your back memo. They need something that says, we think that this is the right thing to do, or no, you shouldn't do that. So I think I don't anticipate a lot of issues going to the enforcement committee. There is an enforcement committee. It is entitled to, it is entitled to enforce. It has powers. I mean, particularly in relation to POPIA, powers to order release of information, which I think is going to be very interesting. So, I think focusing on the worst case scenario is not necessarily going to be very typical of what the regulator does on a day-to-day basis. I think that's going to be a lot more of really just trying to get, I mean, the hardest thing to do with government is to get somebody to pick up the phone, right? That's a lot of what the regulator is going to have to do, is just to help get those systems working. So, yeah.
Okay, there's a question in the Q&A from Carolyn. It's quite a long one though, so I'm wondering, Carolyn, if you're there, if you want to unmute and maybe just ask that question yourself about the collection of disease tracking and tracing data.
Yeah, great. Thank you so much. So how's it, Alison? Yeah, it is a long question. I posted it faithfully because it was posted to me that way. I was asked to post it just for someone who can't attend tonight. Essentially, it runs around the issue of prior authorization and nonprofit organizations that handle, obviously, large amounts of special personal information. Mm. And very often, under the behest of an international, much larger foreign funding sources such as USAID or the United Nations. And it very often involves processing that actually does qualify for prior authorization. And the concern is, obviously when you apply for prior authorization, you have to stop processing for 4 weeks, which in my personal opinion is probably the biggest risk in POPI, is that you literally have to just shut down operations for 4 weeks on that data. And stop that processing. I mean, there's obviously, for people who don't know, prior authorization only has 4 very specific situations. where you do have to apply for prior authorization. So you have that 4-week window period where you have to wait for feedback from the regulator. And if it doesn't come, you can carry on. However, if the regulator does come back and wants to do further investigation, it could go up to 13 weeks of no processing. So that obviously would create an enormous interruption that could have consequences for public good. And then obviously, the larger issue around how do we manage this, sort of where the nonprofits are now caught between the regulator and the funders, international funders. So over to you, Alison.
Yeah, I think the issue with prior authorization is really that it's intended to deal with really quite specific circumstances. It's pretty much the situation in which the sort of framing question, I guess, is why are you doing this at all? And if you're doing this, should you be? The big answer to the question, I think, as far as the regulator is concerned, is if there is a code of conduct that has been issued. Because then the regulator's thought about the issue, is thought about the processing you're doing, and have said, yeah, okay, you've got your code of conduct, this is how you're governing it, okay. And that's why codes of conduct are really going to be important. I think for people who fall outside of a sector that has a code of conduct, that is going to be tricky. And that is one of the issues that the regulator recognizes as being a problem. It's difficult to know how big a problem it is until you've seen whether codes of conduct have been created and cover that processing.
Yeah, I totally agree. Codes of conduct are obviously the easiest way to sidestep that problem. But realistically, for a non-profit organization, I'm not sure what body they would fall under that would issue a code of conduct. And then also just considering the volume of data and just the fact that the wording of for example, the transfer of information about children, if it is transferred outside of South Africa to a jurisdiction. So if I have a cloud system that is hosted in America and I'm using that to process the information about my HIV patients or children or whatever it might be, I'm technically I'm transferring that information to a jurisdiction that doesn't have adequate data protections, and I now need to apply for prior authorization, which is that is the black and white interpretation of what the Act actually says.
Especially if it's trans-border and it's going into a jurisdiction that doesn't have adequate.
And reality is most people are using systems that are hosted in America. That's one of problematic. Yeah.
That's going to be a problem.
So I mean, it is a big question. I suppose it would be fair to say, could you chew on that and come back to us at some point? I think.
What would be very helpful is if you put that question in writing and send it to the regulator, because then it'll slot into the various education kind of processes we have. We have a lot of requests for stakeholder engagements, and what we've actually decided to do is to have 2 engagements a month. And the intention is to take especially questions that are sort of maybe more specific, but apply to quite a lot of different organizations. And then we'd have a webinar on that issue. So we'd be aiming to have 2 webinars a month, and then try to knock back in fact, this very kind of interaction, so that, because what we have right now is all of the commissioners trying to respond to everybody who sends an email, which in one way is great. I mean, I think I've really quite enjoy it as an approach, but it's just as the regulator gains, steam, I think it's going to be very difficult to respond to. It's 19 hours. Everything, as it's, all the different requests as it comes. So I think that's something we're going to let people know on social media when those webinars will be. But the intention is to have 2 of those a month, and then try to have the number of direct engagements with organizations to, 4 or 5 a week, so that it's more manageable, given that there are 5 members of the regulator, and at this point I think 3 executives.
Wow.
So which is it at the executive level? They have people who work for them. Don't worry, it's not just people.
8 people, a little outnumbered.
No, it's more like 20 people. But if you look at this at the most senior level, it's 5 members, and then there are 3 executives where there need to be 5, and those people are still coming in.
Well, I'm very pleased to hear that answer from you. It was more or less what I was expecting. I have been trying to encourage people to please approach the information regulator with issues, to use this grace period to raise those questions. And part of what I personally know and feel is that the regulator is there to be approachable and to be open to discussion, because I think there is an attitude, because there's so much fuss has been made about the fines and the penalties, that people almost have this feeling of, I don't want to stick my head up too high. I'd rather just sort of hover here in the shadows and not, be too visible.
Thanks, Caroline. I see there's another question here about the principle of consent, which is a very interesting issue in my view. I mean, all of these things I find interesting, consent, it's not really a thing, is it? Consent is a bit of a fiction. And that's one of the reasons that the whole law doesn't turn on opt-in and opt-out. So there's lawful processing. And lawful processing can include your agreement to having something processed. But think of it like somebody trying to buy one of your kidneys. You can agree to it, but that doesn't necessarily make it legal, right? So consent is really not the pivot on which the whole thing turns. And precisely because consent, contract, I mean, these are all concepts where it assumes parity of arms. It assumes people are equal in terms of how they come to what they're doing, which is just not, it's not the case. So I think it's a very interesting question. But I think exactly the regulator is saying you have to look at the lawfulness broadly. If you think you're going to get away with, but they opted in, or but they consented, that's going to be a real fig leaf to hide behind. I don't think that's going to be enough. There's a very complicated question here about the operator processes the information on behalf of the responsible party, but I'm afraid that's too much for me to just answer on the fly. I would suggest that you can put that question to me offline if you like.
So Alison, just so you know, I am collecting all of the questions and putting them in a document for you, whoever wants them. So they are all being recorded. Maybe Neil, you can go, because I don't think Alison has view of the other Q&A questions. So maybe we can take one from there.
Yes, there's one here from Nathan Ross, which I know is something that the Law Reform Commission at least considered in the project, and it's an interesting question. So the question is, when it comes to black box AI processing personal information.
That's such a good question.
Yeah, I thought you'd like it. How will the regulator approach the issue of explainability for automated decisions? Is there a tension between innovation and transparency or openness?
Well, of course there's a tension. It's fascinating. It is really fascinating. I mean, one of the principles around this, both pieces of legislation, is transparency. But what happens when you don't know what you're being transparent about? That's the real question, right? Because I say to you, how did you reach that decision? And your answer is, I genuinely don't know. But it's a good decision. And I'm going to do whatever that decision is. And if it means I'm going to refuse you credit, or, you know, I mean, some of the more alarming examples are where bail conditions, you know, whether people are getting bail or not using AI. I think the basic principles that the regulator has to deal with are contained in POPI. So the regulator is a creature of statute. We are not going to be able to go on a frolic where we say, you know, well, you've got to disclose this or you've got to explain that. That's, you know, we're going to be bound by POPI. And if your processing is POPI is in line with the conditions for lawful processing, that's probably going to be about as far as we can take it, although the question of access to information would then maybe be interesting in terms of you having to be transparent about the data sets that you have. If there is anything the regulator can do, I think it's going to be leaning in the direction of transparency. So, you know, you would need to at least explain what data sets you're using and whether or not that personal information has been properly collected and has been lawfully processed. There is a provision in the Act, and I'm afraid I can't remember where it is now, but it deals with the question of making decisions based purely on the processing of information in a sort of AI context. And we've specifically said in the legislation that you're not allowed to take decisions in that way, which I think is something that, again, you know, it's just one of those sections that people aren't too worried about. And I don't really understand why, because I think that prohibition goes to the heart of the way many businesses are using information where they have access to AI. So I think that's going to be very interesting in terms of what happens around that. I think the main thing that we're all going to have to bear in mind is that commercial expediency will have to give way to a rights-based approach. So the fact that it works for you well at this point, you know, in terms of whatever it is your business model is, you're nevertheless going to have to think about, you know, rights to transparency, to access to information, to the protection of personal information. And I think just like, I mean, the whole discussion about medical aids and doctors who are investigated more, some doctors more than others. And then the question was, well, on what basis was that happening? And I think one of the approaches from the medical aids was just to try and explain how their decisions work and what goes into those decisions, and challenging those underlying assumptions is then something that you can do. So I think that's going to be the kind of model, but it's a very interesting section. It's going to be very interesting to see how that, you know, how that can be implemented.
Okay, yeah. That's
Just to say, I've got about.
And maybe just to, sorry?
No, I just wanted to say I've unfortunately agreed to a radio interview in about 5 minutes. So.
Can we ask you one more question that would cover two of the questions from the Q&A, because they're quite similar. I think these questions are just about the application of the Act and whether it applies to sort of everyone, and particularly like sole practitioners who are collecting personal information. Either one of them, for example, was a computer technician who was helping to fix somebody else's computer, and the other person just said a small business owner. Are they required to be compliant, to do anything?
Yeah. I mean, there's some things that people don't have to do because they're a small an individual person or a company, but the intention is effectively, it doesn't matter whether you're one person. The question is, how much personal information do you process? I think that's the thing you've got to bear in mind. You know, if you say, but I'm a small business, well, that doesn't really help me, because you could be a small business selling vegetables or a small business processing personal information whereby you sell it to other people, in which case that's very much something that the regulator would have to be interested in. So I think, you know, I don't think it's particularly easy to say, you know, well, I'm not the one group I think who can be reasonably confident of an exemption of journalists. So if you're a journalist and you have a laptop and you have personal information on that laptop, that is none of my business. And I specifically am excluded, you know, I'm specifically limit on my jurisdiction that I cannot get involved there. So journalists are exempt from the provisions of the legislation. Interesting question as to whether it's journalists and media houses, and what happens when journalists' information is part of the media house's information system. Is there a Chinese wall? The media house obviously can't be exempt, although I think some of them are going to try that on. But, you know, so that exactly how that line is drawn is going to be really interesting. But in theory, the one group of people who can, you know, definitely know that their information is just not subject to our jurisdiction is journalists.
Okay, great. Thanks, Alison. Okay, we're going to let you get to the radio. Where should we tune in if we want to keep listening to you?
Well, it's the well-known radio station UFM out of Rustenburg. The key thing that I'm talking about today is the issue of the Chief Justice and his early retirement. So for the lawyers, yes, he is taking long leave. Yes, the long leave is 6 months. Yes, that does take him to his retirement date. So no, we will not see the Chief Justice again, but it is a normal, it's not unusual for a judge to take long leave and then retire. It's entirely within the rules, and it has nothing to do with him issuing subpoenas or anything else. It's the normal provisions of the legislation that governs judges.
Fantastic. Thanks, Alison. And thank you again for your time, for joining us, and for the insights I don't think we could have got elsewhere. So really appreciate it.
All right. Nice to see you guys. Cheers.
Great. Cheers. Okay, for everybody else who is still with us, we will have a recording of the session, and Rebecca's also recorded the questions, which is great. So we're going to put those up. We'll put them up on our site, LawTechLab.Africa. Rebecca, will we be able to put them up on the meetup pages or anywhere else for people to access them?
I will think about that. I have shared our meetup page on the chat. Perhaps I'll just post the questions in the actual event from today. But I will communicate that if you are an attendee on the meetup link. Otherwise, please feel free to, should I share just what's the easiest way to contact me? Maybe privacy, okay. How will you get a hold of me? I'm happy to just share my LinkedIn profile. So if you are interested in getting those questions or actually joining Legal Hackers and collaborating or participating, then you can do that. So I'll just share my LinkedIn profile for now. Neil, I don't know if anyone wants to, but please feel free to unmute yourself, say hi. We're happy to just stay on the line for a little bit of time if you do want to have some chats. I don't think Neil and I are experts in POPIA, but we can answer any other questions you may have. So please feel free to do so. Otherwise, have a lovely evening, and I'll share my profile now. enjoy the storm. I can just hear the wind and the rain. Thanks, everybody. Bye-bye.